ora koutou. Kia ora koutou. If everybody could please take their seats and we'll get started. No mai haere mai, and welcome everyone in person and also to everyone who's joining us online this evening. Ko Charlotte Moore tōku ingoa. I'm the kaiwhakahaere for the New Zealand Family Violence Clearinghouse, and I'm delighted to be co-emceeing this event with Tupe Solomon Tanuai from the Michael and Suzanne Borrin Foundation. Just before we start this evening, I'd like to open us with a karakia. Me karakia tātou. Whakatakite hau ki te uru, whakatakite hau ki te tonga, kia mā kina kina ki uta, kia mā taratara ki tai. E hi ake ana te atakura. He tio, he huka, he hauhu, tihei mauri ora. Tēnā koutou katoa, kua huhui maina I tēnei pō. Tuarua, ki ngā mate, haere, haere, haere atu rā. He mihi ki te iwi e taunei, taranaki whānui, tēnā koutou. I te minata, Marama Davidson, tēnā koe I te rangatira. Kia tātou e taunei, ka nui taku mahi. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Kia ora everyone, and welcome to this evening's event to hear about research led by Elisabeth McDonald, exploring how sexual violence is addressed in our courts. I'd first like to also acknowledge that today is International Women's Day, and so the kaupapa of this evening feels particularly resonant. I'd also like to acknowledge the recent passing of two wahine toa, Georgina Bayer and Hiniwirangi Kohu Morgan, who both made significant contributions to the kaupapa of addressing sexual violence. Moi mai rā I ngā rangatira. One of my main roles this evening is to apprise you all of the following important health and safety information. Should the fire alarm sound, please evacuate the venue via the same route you entered or via the nearest safe exit. Please follow the directions of security staff and fire wardens. The evacuation assembly point is at the rear of Parliament. In the event of a medical emergency, please refrain from calling 111. Inform security or venue staff immediately. Security will manage any medical emergency within the parliamentary complex. In the event of an earthquake, drop, cover and hold until it stops. Please keep away from windows and other obvious hazards in the venue. Please remain inside the venue and await instructions from the security staff. On arrival, you were issued with a visitor sticker. Please ensure it's clearly visible and do not remove or discard it. The toilet facilities for the banquet hall are located in the far corner of the hall near the main entrance. All Parliament buildings are smoke-free. Guests are only welcome to smoke outside the main gates on Molesworth Street. Please switch your mobile phone to silent for the duration of the event. Photos are permitted within the venue space within here, but please do not take photos outside of this room. Division bells. Every Tuesday, Wednesday and Thursday during sitting weeks, the division bells will sound for the members in the debating chamber at 1:50 p.m. and 6 p.m. and again at 6:52 p.m. and 10 p.m. on Tuesday to Wednesday and 5 p.m. Thursday. The division bells may on occasion ring outside of these times due to voting in the debating chamber. I'm just checking my notes to see what we're supposed to do in the case of a plague of locusts. There doesn't seem to be any specific instructions, so I guess it's every person for themselves. On a more serious note, Elisabeth's research touches on issues that are upsetting for all of us, but which may be particularly triggering for people with lived experience. If anyone would like further information about support services available, you can find links on the New Zealand Family Violence Clearinghouse website, which is nzfbc.org.nz. The recording for this event will also be made available on our website. The New Zealand Family Violence Clearinghouse is the National Centre for Family whānau and Sexual Violence Research and Information, and our role is to act as a conduit for knowledge transfer between those working in the family and sexual violence sectors, researchers, policymakers and legislators. This evening is a great opportunity to not only hear about Elisabeth's research, but also to connect across our legal, policy and community sectors. I hope that this evening challenges us all, whatever our role in this mahi is, to make changes that are required to improve the lives of victim survivors and their whānau as they navigate their pathways to justice and healing. Kia ora. I will now pass the rākau over to Tupe. Tēnā koe, Tupe.
Kia ora, Charlotte. Tangihi o tātou tini mate, haere, haere, haere. Tātou kua māhue nei, kia ora tātou katoa i ngā āhuatanga o te wā. Aio ki te rangi, aio ki te whenua. Aio ki ngā mana, ki ngā reo, ki ngā iwi katoa. E ngā mana, i ngā reo, i ngā iwi, e raurangatira mā, tēnā koutou katoa. E te Minita Davidson, tēnā koe. I ngā kai whakawā o ngā kōti, me ngā rangatira, tēnā koutou. He mihi nui ki ngā mana whenua te rohe nei, Aotearoa, taranaki whānui, Ngāti Toa Rangatira. Ki te hunga kua tai mai ki te tautoko i te whakarewatanga o te pukapuka nei, e pā ana ki ngā take taumaha o te oranga o te whānau. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Good evening, everyone, and talofa lava. I'd like to start by acknowledging the many families and communities still dealing with the impacts of Gabrielle. At a time when the basics of life have become so difficult, it's even more important to ensure access to justice for all. Our deepest gratitude to the Honourable Marama Davidson, our host for this evening. And thank you to members of Parliament, members of the judiciary, members of the legal profession, victim survivors, friends and supporters who are here tonight. Welcome also to those joining us via live stream from as far away as New York. Thank you all for your presence at the launch of this new publication on intimate partner rape and the trial process. My name is Tupe Solomon Tanawai, and I'm the Chief Philanthropic Officer of the Michael and Suzanne Borrin Foundation. I would like to acknowledge our Chair, Justice David Goddard, as well as members of our Grants and Scholarships Committee who are here tonight. It is our pleasure to partner with the New Zealand Family Violence Clearinghouse for this event. At the Borrin Foundation, our vision is for an Aotearoa New Zealand where everyone knows and understands the role and value of the law, and everyone enjoys the opportunity and protection that it provides. We're here to make a difference to the lives of New Zealanders through the law, and we do that by funding legal research, education, and scholarship, and supporting the change makers like Professor Elisabeth McDonald, who contribute to our shared vision. We are proud to have supported this work, which offers a more informed place from which to improve the complainant's experience in rape trials to ensure a fair trial process for both complainants and defendants. Tonight, Elisabeth will give us an overview of her research with a focus on her new publication, and then Minister Davidson will say a few words in response to the findings. We will then have a Q&A with Elisabeth and contributing researchers, facilitated by Professor Nicola Gavey, who is the Tau Iwi Academic Co-Director of the New Zealand Family Violence Clearinghouse, and a Professor of Psychology at Waipapa Matarau, the University of Auckland. Then we will hear from Catherine Montgomery, the publisher for all three of Elisabeth's books at Canterbury University Press, who will officially launch the book. Now, one of my tasks for this evening was to introduce Elisabeth, but she's assured me that you all know her quite well, so she's asked me to keep it short. So it is my privilege to welcome Elisabeth, who has taught and published in the areas of sexual and family violence, law and sexuality, criminal law and the law of evidence for over 30 years, and is currently adjunct professor of law at Te Whare Wānanga o Waitaha, the University of Canterbury. Without further ado, I ask Elisabeth to take the stage.
Eina mana, eina reo, eina iwi, e rā rangatira mā, tēnā koutou, tēnā koutou, tēnā koutou katoa. Thank you. Where's she gone? For that kind introduction, and to Charlotte for the generous support of the New Zealand Family Violence Clearinghouse for this event. Your Colin Megan Sete, who's probably hiding down there, yes she is, has been the powerhouse behind the evening, and I'm very grateful, as we all are, for the hundreds of details she cheerfully and meticulously attended to. This will be the beginning of many acknowledgements through the course of tonight, which I plan to weave into this lecture. First, I'd like to mark my appreciation to Justice Rachel Dunningham, who was the MC for the launch of the first 2 books as part of the UC Connect lectures in Aotearoa. The leadership and engagement of the judiciary with regard to issues related to the prosecution of sexual offences, and with regard to the position of vulnerable participants in the criminal justice system more generally, including the focus on te ao marama, is very heartening. I acknowledge the members of the judiciary here this evening. Thank you. But also the many who cannot be here, whom without this research would not be possible. It was only possible due to the faith and trust placed in me by the heads of bench over a number of years, including the now Chief Justice, Dame Helen Wynne-Kelman, when she was the Chief High Court Judge, Justice Dan Joog, when she was the Chief District Court Judge, and more recently, Justice Jeff Fenning, Chief High Court Judge Justice Susan Thomas, and Chief District Court Judge Hemi Tumanu. Their support ensured that trial judges were confident in granting me permission to access more than 70 rape trial files concerning cases heard between 2010 and 2020. Thank you all. I also want to thank the officers of the Crown Solicitors, Police, and Crown Law for assisting with identification of the cases relevant to the project. The National Transcription Service, especially the amazing Lyle Ramsey, for providing us with the necessary case materials. I acknowledge people who've travelled here this evening, from Sydney, Tamaki Makaurau, Rotorua, the Waikato, and Aotearoa, that's an in-joke. I appreciate the presence of sector advocates, survivors, members of the legal profession, academics, students, this is in no particular order, Minister, members of Parliament, supporters of and contributors to this work, colleagues from Te Kura Kai Whakawā, members of my family and good buddies. Thank you for being here. I appreciate your engagement with this work, and for those who cannot be here, but I know who are attending virtually, nau mai, haere mai. Attending virtually has, of course, been the new normal for many of us since the launch of the first of the 3 books on the 26th of February 2020. Since then, the world has been impacted by the pandemic, by the violence in Ukraine, the earthquake in Turkey and Syria, and most recently in our beautiful Aotearoa, extreme weather events. Given all that has challenged us globally over the past 3 years, it seems rather indulgent to be musing about one aspect of the criminal justice system in our relatively small island nation. However, the issues I wrote and talked about 3 years ago, and actually for the first time over 30 years ago, have not gone away, been resolved, nor can they or should they be forgotten. For far too many, the impact of sexual violence will forever mark their lives and consequently their well-being. Although I strongly support prevention and education initiatives, and who would not, as well as meaningful and effective alternatives to prosecution, while the adversarial trial process remains the primary way that our criminal justice system addresses the harm caused by the rape of an adult woman, this area remains a key focus of my research and my thinking. The first book, originally planned as an only child, but now the first of a trilogy, or to continue the analogy, triplets, examined the impact of rape myths and misconception on an adult complainant's experience in the trial process in 30 jury trials. The observations from that research led us to conclude that despite decades of law reform, there has not been any significant change to the dynamics of questioning complainants, and therefore no significant reduction in the distress and re-traumatisation experienced by those women. Some further changes have now come into effect as of the 21st of December 2021, due to the passing of the Sexual Violence Legislation Act 2019. However, while some of those changes are responsive to the findings of the first book, they are all based on recommendations made in 2011 and even earlier. Law reform can be, as we know, a slow process. However, not all the changes we recommended required legislative reform, as is the case, for example, regarding judicial control of the trial process. I want to begin my overview of the findings of the intimate partner rape research by making some overall observations about adult rape trials, whether by jury or judge sitting alone, and including cases in which the defendant was also charged with other types of violent offending. All of these cases involved an adult male defendant, and with a couple of exceptions, an adult 18 or over female complainant, and they were both adults at the time of the alleged offending. In all of these cases, the issue at trial was consent or belief in consent. As such, based on other research over 4 decades, these were the types of cases in which complainants reported experiencing a highly distressing time giving evidence. These also happen to be the cases in which conviction rates are the lowest, but this is not a focus of this work. This work focused on recording what happens behind the courtroom door, making proposals to reduce the negative impacts on complainants who participate in the trial process, while keeping the fair trial rights of defendants firmly in mind. While we would not wish the role of a rape complainant on anyone we love, at the same time, nor do we want anything less than a robust defence to be available for a family member accused of a serious crime such as rape. While we ask, appropriately in my view, for a trauma-responsive criminal justice system, we know that many defendants also do not come to the courtroom free of a difficult past and may be facing an unfamiliar place, unfamiliar language, and unfamiliar rules and customs. In the end, and bearing in mind that we increasingly know more about the nature of human trauma, memory, observation, recovery, decision-making, bias, and communication, it just might be that the adversarial trial, criminal trial, is not, nor has ever been, the best way of determining truth and providing resolution. This research has been a challenging exercise. We hope it is one that appropriately pays tribute to the lives of the women complainants whose words and experiences we have written about. While the research was focused on reducing the trauma involved in giving evidence in a rape trial, access to these cases also demonstrated the level of concern, commitment, and relentless personal strength required by all participants in the trial process. While some of the interactions recounted in these books and in this lecture, which I must say are the minority of examples, reveal that lawyers' or judges' practices are not as we hoped they would be, but there is no doubt that these professionals are performing a necessary public service that many would shy away from. There is no need, in my view, for criticism of individuals. Rather, this is a time for aiming for systemic and structural change based on a shared willingness and desire to do things differently. The importance of this research was acknowledged by 4 funders, beginning with the Royal Society Marsden Grant, which allowed the development of the methodology and the access and analysis of the 30 primary comparator cases. The Law Faculty of the University of Canterbury, who supported the publication of the first open access book. The New Zealand Law Foundation support allowed access to an analysis of the sexual violence trial pilot cases, the judge alone trials, as well as publication of the second open access book. And the Michael and Suzanne Borrin Foundation funded the 2019 workshops on reform options, the research on the intimate partner rape cases, the publication of the third open access book, and the launch of that book tonight. And seeing as they're sitting here, I think that needs a big hand of applause. And there's drinks as well. So. It must be said, I think, that in the absence of the financial support from those funders, without the work they do ensuring the identification of important change-making initiatives, major projects like this one simply would not happen. Nor particularly would open access publication be possible. It was carried out in these cases on these three books by the exceptional Katrina McCullum, who sadly can't be here tonight, and Catherine Montgomery from Canterbury University Press, who can be, and the extraordinarily talented Robin Greathead at Treehouse Type and Art Workers Sydney. The print versions of these books are also available to order or will be in due course, and I encourage you to do so, as all the royalties will go back to CUP because they did all the in-house work for the first two publications for love. So they can continue to support access to academic research. As all academics and researchers appreciate, writing requires a team effort, and all four of us were blessed by exceptional home support as well as by generous peer reviewers, including for the book being launched tonight, local and international luminaries, Professors Heather Douglas from Melbourne, Jeremy Finn from Canterbury, Scott Optigan from Auckland, Judge Bart Morris will be looking down right now, and Professor Nicola Gavey, who I'm very pleased to have beside me facilitating the Q&A this evening. So, we know that complainants say that giving evidence can feel as bad or even worse than the rape itself. We wanted to know if hearing what happened at trial by accessing the audio of the complainant's evidence would illuminate why complainants make that claim. One level of this analysis involved listening to the audio, transcribing the interactions in the courtroom which do not form the notes of evidence, and recording the points during the complainant's evidence, which Paulette Benton-Gregg, the researcher on this journey from the beginning, helpfully framed as episodes of heightened emotionality, and including for the purposes of this research, a range of responses or reactions: distress, silence, anger, discomfort. This listening to the voices of the complainants and coding for deployment of misconceptions was undertaken by Paulette in relation to the primary comparator group of 30 adult rape trials, and by Sandra Dixon in relation to the 10 sexual violence court pilot cases, the 15 judge-alone rape trials, and the 15 intimate partner rape cases. This was an enormous, and as you will appreciate at many times, a harrowing task, but provided the essential material that allowed the analysis presented in these three books. Thank you both, and for the thinking, insights, and support across the whole project. Transcribing the non-evidential interactions in the courtroom, the basis of counsel's objections, the legal discussions in the absence of the jury concerning admissibility, the words said by the judge directly to the complainant, meant we were able to comment on the dynamics of those interactions and the application of the rules of evidence. Rachel Souness, who cannot be here this evening, was primarily responsible for transcribing and annotating the closing arguments and summing up, as well as counsel submissions and reasons for verdict in the judge-alone trials. Her knowledge of criminal law and evidence was particularly valuable, as well as her energy for this work. Thank you, Rachel. Across the 70 cases analysed, we noted patterns of trial dynamics that impacted audibly on complainant heightened emotionality. I'm just going to go through those now and to note that these were present in all cases to a greater or lesser extent. So these were the points where we noticed there was distress, audible distress, where there was silence, where there was just a failure to speak at all. And the first group of where this happened, and it's probably not a surprise to you, is when the complainant was challenged about her behaviour because it was not consistent with real rape, or the behaviour of a real rape victim. That is reliance on misconceptions, whether that was a failure to make an early complaint, the fact that there was no struggle or resistance, the kinds of clothes that she was wearing, the fact that she had ongoing contact with the defendant, or that in fact she'd invited him into her home. There also seemed to be an expectation that complainants would remember minute details of what occurred around and at the time of the offending. There was constant questioning about the inconsistencies of the complainant's evidence over time. Again, there was heightened emotionality when there was repetitive questioning on the distressing aspects of the events, when complainants had to give evidence of the details of the alleged offending, where there was mocking or belittling questions, and there was questions about things that we thought were irrelevant. Now, obviously not all of those things that gave rise to heightened emotionality can be avoided, but what we wanted to know is, can the impact of that kind of intervention, or those kind of questionings, be reduced? We also noticed the lack of uniform, robust engagement with admissibility rules. And some of you will have heard me say these things before, and they came up again in these particular intimate partner rape cases. So one of the things that we noticed was how often evidence of the complainant's occupation was given in evidence, even though under Section 88 of the Evidence Act, and even prior to that under the 1908 Act, that evidence is only admissible if it is of such direct relevance that it would be contrary to the interests of justice not to offer it, to exclude it. And sometimes the complainant had to say that they were unemployed or a beneficiary, and that was right at the very beginning of their evidence. Often there was evidence offered about personal information around the complainant, about their mental health, which seemed to have no relevance to the actual events, about what kind of medication they were taking, and what medical interventions they had had, including whether they'd had a miscarriage or an abortion. There was also evidence offered on occasion as supposedly being relevant to the complainant's credibility, including evidence of her previous driving convictions or driving under the influence of alcohol. And as you will know, and I'm going to say later, sexual history evidence being one of my things I hone in on, some difficulties there. We also noticed the absence of possible responses to complainant distress or at the process of giving evidence. So we noticed very low levels of intervention by counsel and judges, and in fact, in 40% of the cases, and only 40% of the cases, was there any intervention from the judge at all. And that could have been just once in the trial, and that was counted as part of the 40%. And mostly those interventions were a matter of form, not substance. So that's a complicated question, maybe ask it again, but there was very little intervention at the types of questions that were being asked. Let's rush out and vote. It's a little early, my clock does not say 6 p.m. All right. So that's what we noticed. We also noticed the absence of expert evidence, Section 9 statements, so those are agreed statements of fact that can be offered, or directions providing a counter-narrative. So no counter-intuitive expert evidence was offered in any of the 48 adult rape cases, not in one. There were some statements made by the judge in relation to delay, which is required under Section 127 of the Evidence Act. But I have to say that in all these cases, there were very high levels of immediate or very early complaint, so delay was hardly ever an issue. That may have been one of the reasons behind why those cases came to trial, of course, as well. And there was an absence of limited use direction. So, and I'll come back to this because there were a number of cases where evidence of the complainant's sexual history was seen as admissible because it said something about her credibility. But the jury was never directed that that was the only purpose to which they could put that evidence. Notably, all of these observations in terms of heightened emotionality, the dynamics at the trial, the kinds of questioning, the application of admissibility rules, also applied in the 15 judge-alone trials that we looked at. And as I reported in the conclusion of In the Absence of the Jury, and this was repeated in the analysis in the Intimate Partner Rape book, so there's chapter 8 in that book talks about the judge-alone intimate partner rape trials. The overall sense of the cross-examination of complainants in the 15 judge-alone trials was of similar but less controlled questioning as compared to jury trials. So rather than emboldening judges and Crown Counsel to object more, given the absence of the jury, or a jury, the reverse appeared to be true. In the absence of any risk of unfairness to the defendant by the nature of the complainant's response to unfair or inappropriate questions, or the admission of irrelevant evidence, she was very much left alone to fend for herself. So therefore, those judge-alone trial studies indicate that the most significant difference in trial dynamics, cited by advocates and law reformers in support of rape trials without juries, does not exist. That does not mean that the potential for difference in terms of improving complainant experience does not exist. Rather, that in this group of 15 cases, that potential was not realised. So, with that overall background in mind, I'll now turn to outline some of the findings specific to the intimate partner rape cases. My first observation is to share information about the high level of multiple complainant vulnerabilities. In the total of 20 intimate partner rape cases, 4 complainants gave evidence of managing significant mental health challenges, including post-traumatic stress disorder and being bipolar. Another was described by the defendant as retarded, and a further one referred to by the defendant as dopey, with the judge noting during a discussion with counsel, "I've no idea what it was that was difficult in the first place, but she seemed not to be clear about basic questions and not understand things." 3 other complainants attempted suicide close in time to the alleged offending. 14 complainants gave evidence of being strangled or unable to breathe for periods of time during the alleged assaults or rapes. 1 sought medical assistance for concussion, and 1 reported a loss of hearing as a result of head injuries. As you may know, loss of oxygen to the brain can cause traumatic brain injury, which has implications for cognitive difficulties. Therefore, of the 20 complainants, only 3 reported an absence of brain injury or mental health issues. In other words, 85% of the intimate partner rape complainants had conditions that may well have affected their cognitive abilities at trial, including the impact of strangulation on brain function. No communication assistance was provided to any of these complainants. High levels of distress were also apparent. 1 complainant, for whom English was not her first language, even spoke of the challenges that have been reported by other complainants to researchers, including most recently by the 2018 Ministry of Justice and Gravitas work. I'll just read some of this out. "When I reported to the police, I just want him to stop coming to my place. I did not want him to be imprisoned. I didn't want anybody hurt, but now I've been hurt so badly. I'm very hurt, and in front of all these people, like being unstripped. I didn't think I would be stripped off like this. I felt very upset when I want to say something and you only want me to say yes or no. For such a long time I could never speak to anyone. I've almost forgotten about this, and the police has been talking to me and say if I don't come to court, other women might get hurt, so I came." So in that interchange with the judge, she's complaining because the complainant is saying she wanted the defendant to stop, not for him to be imprisoned. After she reported she wanted to forget about it, but she was forced to remember and go back to give evidence at trial for public safety reasons. She wants to say something in the courtroom, but all she's allowed to do is say yes and no. And she feels very exposed. The translation of her word is unstripped. In the intimate partner rape cases, complainants were also asked to give irrelevant evidence, which often, in my view, had a pejorative overlay. And in relation to these next 3 jury trial examples, no attention was given to this evidence in the closing argument or summing up. So the evidence was just left there. The jury wasn't given any guidance as to the forensic value of that information that had become part of the evidence at trial. And here's the first one. The next thing that happened was lunchtime, wasn't it? I guess so. And you guys have a habit of eating takeaways as your core diet, don't you? Well, in the days that are recorded in this bank transaction, you've been to a variety of takeaway stores already, and we've seen you've had McDonald's for breakfast on 2 consecutive days. No relevance to any of that. What's your nickname? Stretch. Why do they call you Stretch? It's been my nickname since primary school. How come they call you Stretch? I used to fight at school. I used to be the bully. And finally, one you hope that you don't see very often. When he's on top of you and he's ripping your top, what did you have on? What were you wearing? I was wearing black leggings, quite thick leggings, a black cotton singlet. Over top of it was like a chiffony tie-dye top. And underwear? Yes, I had my bra and underwear on. What kind of underwear was it? What style? Cotton briefs. And the style? They're called boys' legs. As many of you will be aware, as I said earlier, the admission of sexual history evidence has been an area of research for me for some time. So across all the cases, it's been an aspect that I have commented on. In the intimate partner rape cases, it was also apparent that evidence of the sexual experience of the complainant was often admitted without argument, and on the basis that it was sufficiently relevant to the assessment of the complainant's credibility, which actually has been recognised as being one of the twin myths that Section 44 was aimed at preventing reinforcing. And in fact, the Ministry of Justice even said this in their advice to the Select Committee during the legislative process of the Sexual Violence Legislation Act. The restrictions on evidence or questions about a complainant's sexual experience with people other than the defendant guard against the twin myths that a sexually active person is more likely to have consented to sex with the defendant and is less credible as a witness. In the intimate partner rape cases, the kind of evidence that was admitted included that the complainant had a sexual relationship with a woman after she left the defendant, that the complainant had sex with a younger man during her agreed non-exclusive relationship with the defendant, and that the complainant had lied about having sex with 2 other men while she was separated from the defendant. In this one 2014 case, the judge agreed with Defence Counsel that that kind of evidence was admissible as being of super relevance to the assessment of her credibility and to the likelihood of her consent. When I say super relevance, the test again is of such direct relevance that to exclude it would be contrary to the interests of justice. And the Court of Appeal has said on a number of occasions that that is a high, strict test. And the judge said, I agree that the cross-examination of the complainant to the extent to which the defence wished to do so, namely that she did admit to the defendant to having sexual relationships with 2 men during the relationship and that she'd previously lied to him about this, is relevant to the issue of credibility and then to consent. It's good to see a few shaking of heads around. In my view, I can't see how that could possibly be relevant to consent to the defendant, and I would also query whether it says anything about her credibility relating to the allegations. It certainly cannot be veracity evidence, as it's not about her general propensity to be untruthful. And I want to give a nod to the recent statement of the Court of Appeal in the case of Kumar, 2022-106 at paragraph 22, where they say proof of a single lie is seldom capable of being substantially helpful in assessing a disposition to refrain from lying. I want to move on now to talk about one of the things that this particular research has illuminated, and that is to do with the admissibility of sexual history between the defendant and the particular complainant. A somewhat controversial reform to Section 44 of the Act took effect on the 21st of December 2021. And Section 44 therefore now provides that evidence of the complainant's sexual experience with the defendant is also only admissible if it passes that super relevance, heightened relevance test. It does now contain an exception for evidence of the mere fact of a previous sexual relationship, and that evidence is admissible only to Sections 7 and 8, which govern relevance and probative value. It was argued during the legislative process that Sections 7 and 8 should be sufficient gateway for all evidence of the sexual experience between the complainant and the defendant. And this was the position for all of the intimate partner rape trials in this research. So evidence about what happened sexually between the complainant and the defendant was only subject to sufficient relevance. But what is apparent in my view, having looked at these cases, is that Sections 7 and 8 alone did not operate to prevent the admission of insufficiently relevant evidence. Examples of such evidence included how soon after the complainant and the defendant met did they first have sex, and how often during the relationship did they have sex. Sex would be 2 to 3 times a week during the working week. Is that about right? I couldn't tell you, but possibly. More? I couldn't tell you. More on the weekends and holidays? I don't know. And where they had sex. Nathan said you decided to go to a concert, you took your child to the grandmother's, dropped her off, and as you were heading back into town, you said to Nathan to pull over, and then you had sex in the car. He wanted to do that, but you were quite keen too, though. Yes. Now, the alleged rape did not take place in a car. There was absolutely no relevance of the fact that they'd previously had consensual sex in a car on the side of the road. That evidence went in and there was no explanation on why the jury was supposed to hear that and what they were supposed to do with it. So the point of making that, of showing you those examples, is to say Sections 7 and 8 seem to not be stopping that kind of evidence coming in, and I would support the change to the legislation. Also, in the intimate partner rape cases, there was a lack of material regarding the dynamics of family violence. So in only one of the 20 intimate partner rape cases was there expert evidence offered, and that was in a judge-alone trial. And in one of the judge-alone trials, the judge self-directed about the forensic meaning of counterintuitive complainant behaviour, including delayed complaint, continued contact with the defendant, and the complainant's failure to remove herself from harm's way. The Sexual Violence Legislation Act made changes that were designed to impact on some of the trial dynamics we observed. In particular, Section 44 has been amended, as I said, to extend the super relevance test to evidence about the sexual history of the complainant with the defendant. Section 85 of the Evidence Act has been changed to a mandatory requirement for judges to intervene when there is improper or unfair questioning. And the section now includes a specific reference to how the question is asked, the cumulative impact of that questioning, and the importance of taking into account the vulnerability of the witness. Section 126A requires judges to direct juries about misconceptions in sexual cases. A broad range is listed, and the section is intended to provide all juries with a counter-narrative, even in the absence of a Section 9 agreed statement or expert evidence. This is a promising start, but it's just a start. I'll finish with what I see as the priorities in this space. Firstly, the development of misconception directions in family violence cases. This was recommended by the Law Commission in their second review of the Evidence Act, Report 142. The government responded by saying they needed more time to consider the budget implication and resource implications of this recommendation. The second thing, and I haven't had time, I think this is sort of a lecture on itself to go down the consent rabbit hole, if you like, but one of the things I did notice in this group of cases was the lack of attention paid to the impact of coercive control on the real possibility of actual informed consent. So I see that as something, and this is not something that's new, this has been thought about, talked about for a long time. I also think what needs to happen is an impact of the reform that I've just talked about that's already been enacted. And I think the one thing that's been amazing about the work that we've done is that it will be, I think, a really good baseline comparator for future work that maybe the Borrin Foundation will fund. But also will include, I think, a look at what the appellate jurisdiction is doing in relation to those changes. And I have a particular hope that they will provide trial judges with confidence to, in particular, firmly control questioning under Section 85. And the last thing I want to come to is this one, alternatives to the adversarial trial process. What I said before is that this research took place in the context of an adversarial trial model. It wasn't about what could be different, although it's given us some pretty clear messages that it's not working very well for a range of people in a number of different ways. And I wanted to close with something that Warren Young, who many of you will know from his various roles, both in Justice and the Law Commission at the university, and he said this: "We need to be looking for alternative ways of dealing with complaints which can better address the needs of victims. We need to be open to innovative possibilities and be prepared to experiment with and evaluate them. That is where I hope we will have moved to in 10 years' time." Now, some of you were probably there in the room when he said that in 1996. In 2023, 27 years on, it must now be time. Ngā mihi.
Thank you, Elisabeth, for those sobering insights and for providing the information needed to support effective responses to sexual and family violence. It is now my privilege to introduce the Honourable Marama Davidson, Minister for Prevention of Family and Sexual Violence. Prior to becoming an MP, Marama worked for the Human Rights Commission for 10 years and was the chief panellist for the Glen Inquiry into domestic violence and child abuse. Her involvement in the inquiry placed violence at the forefront of her political radar. Marama is passionate about all areas of injustice and is committed to using her voice wherever she can to elevate issues. Please welcome the Honourable Marama Davidson to the stage.
Mō te oranga o ngā whānau, o ngā mokopuna, o ngā hapori katoa te take. Anō reira tēnā koutou, kia ora mai tātou katoa. I'm feeling a lot like an M&M rap at the moment. My palms are sweaty, my heart is beating. And throughout your entire kōrero, Elisabeth, as we're sitting in this room, and you know, this is the beehive. It's just obviously gives off the status of statelyhood, etc. And I'm not used to, I don't know about all of you, but I'm not used to being in a big room full of esteemed people, and especially esteemed people who are survivors. and having such raw conversations about something that mostly in ordinary life we don't talk about, and that is part of the problem. Probably also feeling very anxious and understandably accountable, but also because and this was put out many years ago, being a survivor of sexual violence and seeing things reflected back that make absolute sense, just absolute sense. I just want to thank Charlotte for making it clear that there is support available for people who may also be feeling like a bit of a clutch around my chest right now. This is exactly the conversation that we need to be having. And I thought the only way I'm going to get through my speech at all is by being really upfront about how confronting this is for all of us, and therefore how important. So with that, if you don't mind, I'm just going to grab a drink of water. All right. I really do mihi to our ministers and MPs doing this work and those in this room, including Honourable Kelvin Davis, Honourable Louise Upston, MP, Golriz Gadaman, Jan Logie, and the judiciary who have joined us. Dame Helen Winkelman, sworn in as New Zealand's 13th Chief Justice. Dr. Kim McGregor, I'm right there in front of you, hello darling. Chief Victims Advisor, Tupe, Solomon Tanuai, our Chief Philanthropic Officer at Michael and Suzanne Borrin Foundation, Charlotte. Dr. Charlotte Moore from the New Zealand Family Violence Clearinghouse, officials all in the room from Te Puna Aonui, Ministry of Justice and MSD and other agencies who are here with us tonight. We've all got work to do, each and every one of us. And most importantly to you, Professor Elisabeth McDonald, to you, Elisabeth, author of Prosecuting Intimate Partner Rape. You have our respect, our admiration, our gratitude for doing this work, this critical mahi. Thank you, Elisabeth, for your commitment and perseverance in continuing to raise up the voices of victim survivors and to ensure we have the research, the information, and the hard conversations that are necessary for change across our system, in our communities, in our whare, in our homes. It's not lost on me that we are here today on International Women's Day. I had the privilege of being emceed by Tupe this morning at the breakfast in this very room at a table that was right there is where I was sitting. And we must celebrate the achievements and successes of women in Aotearoa all over the world. And of course, there is so much more to still be done until women are safe and living peacefully, free from violence. We know that women are 3 times as likely as men to experience intimate partner violence, and that wahine Māori are more likely to be impacted by violence than any other ethnicity. Here in this room tonight, we know there will never be equity for women until we have healed, addressed, and eliminated this violence that impacts on all aspects of our lives, especially women's health, happiness, and aspirations. And we know that we can only do this when we centre the needs of victim survivors across our system and when we collectively address the harmful social narratives and beliefs that underpin violence in all its forms. Whenever I speak to the gendered nature of violence, there is always an elephant in the room, because I hold the gendered nature of violence strong and staunch, and I acknowledge that all genders have also been victims of violence, including sexual violence, and that in fact it is the very gendered nature of violence that makes it hard for boys and men to receive support as victims of sexual violence because of that very gendered nature. And I know there is discomfort in holding the gendered nature of violence to the forefront. These are not trade-offs. They are part of the same oppressions. The very aspects that make it hard for male and boy survivors is exactly from the gendered nature of violence. So I just put that there, bring that right out. As this country's humbled First Minister for Prevention of Family Violence and Sexual Violence, I carry the voices and the mamae, especially right now, of all family violence and sexual violence survivors with me through everything that I do. I also carry with me the memory of those who have lost their lives to violence and the trauma and pain that continues through their families for future generations. They demand of us all that there is no time to lose to do this work, and I remember and acknowledge the quote that was looking forward to some explicit change in 10 years, and here we are decades later, generations later. So that is why it is important that we gather here tonight to acknowledge and salute you, Elisabeth, and the work that you have produced. For as long as we face the issue of rape and the wider issues of family violence and sexual violence, this mahi will be essential, as will the thinking, the research, the evidence that stems from this book, and the conversations it facilitates, and the clear need it highlights for all of us to continue working to drive change, because this must change. This evening, I also want to directly acknowledge the victim survivors of sexual violence first and foremost. We hear you, we believe you, and we will not give up until we have a system and a country that respects, believes, and safely supports victim survivors when they reach out for help. And we will make that necessary shift to prevention and healing work so that users of violence are held to account and supported to change their behaviour so that we can stop violence happening in the first place. The quote that you mentioned about the person who said they didn't want their partner to be taken away by police or go to jail, they wanted the violence to stop. And I mentioned to Charlotte when you said that, I've heard so many times across the country. I've literally had the quote, I didn't want them to take him away. I wanted him to stop hurting me. Those are two different things. And so that also really triggered the voices of survivors coming to me, and I thought I have a real responsibility to highlight also what I'm hearing. One of my priorities is to make sure that everyone feels they can ask for help, and that when they do, they are met with a response that is right for them and their whānau, that stops the violence and supports people to heal. Our country is crap at healing. We are having to build that understanding up for all of us. And it is because we haven't had that proper understanding and skill and acknowledgement of the importance of healing that intergenerational violence continues. So intergenerational aroha and healing is what will end that. The book we are launching, Prosecuting Intimate Partner Rape, is an important addition to the literature and the research that we have in this area. It helps us better understand the experience of rape and sexual violence victim survivors experience throughout our justice system, and how we continue to re-traumatise people through power of the system and inequities, labels, judgments, cultural bias, racism, classism, and ignorance. This book makes a huge contribution in helping us all better understand and name the rape myths and pervasive attitudes that infiltrate our society, media, and the justice system. This includes ideas about people's sexual history and that women are responsible for rape or assault due to how they dress, how much they drink, where they walk, and how they react to the assault. And the myth that real rape is rape by stranger, not by people who know us and live with us. It highlights the very belief that many in our society subscribe to, that real victims of rape and violence should behave and respond in a certain way, that they should leave their partners, fight off their assailants, and report crimes immediately. Now here is where, as I was preparing my speech for tonight, is where I had to have a bit of a think about my own work and my massive responsibility and privilege to lead intergenerational elimination of family violence and sexual violence. And that if we cannot acknowledge our human experiences, we will not be able to fully exploit the value and taonga that we all have among us as well. And so, Elisabeth, as I was reading the particular part in the book, the excerpt from the book around those very myths, and I looked down them and I highlighted them. And it begins, for example, by that very aspect, that very myth of true rape is rape by a stranger. It goes through examples like victims do all they can to resist, victims fight off their assailants, we can always withhold consent, only stranger rape is really traumatic, and that genuine victims report rape immediately. And every single one of those myths is exactly what I experienced in my own experience of significant and prolonged, sustained sexual violence as a child. Every single one of those spoke to me personally. He was not a stranger. I did nothing to resist. I did not fight off him at any point. I had so much fear that I didn't even know how to not consent. It was traumatic, even though he was from my own family. And it took me 4 decades to tell anybody. So thank you for validating many of our own experiences, and that is such a myth. Such a dangerous, harmful myth, and one small aspect that needs to change in the area that you have highlighted. And I thought it felt wrong for me to read this and to stand here with my role in this work and not make that a connection. Also, I acknowledge that I consider myself to be a privileged survivor with resilience factors and protective factors that have not been available to everybody, and that I have a functional place and role and work to do and purpose, and I am guided by the sector, the experts, the lived experience, the agencies, and the best that we've got to offer collectively, and that if I did not stand here tonight and connect personally with exactly what you are highlighting to us, that would have been a sad missed opportunity. So thank you. So then I can probably flick through a good 3 pages of my speech, because I just expressed it a whole different way, and start to move then into the mahi. Te aurere kura, and the 40-point action plan is what I really knew I had a responsibility to come and highlight tonight. We've taken some big steps in recent years to look in those mirrors across the broader family violence and sexual violence sector. The steps forward that we are all committed to taking are many. But tonight, as Minister for the Prevention of Family Violence and Sexual Violence, I also want to share a little with you about a fundamental part of the ongoing commitment to solutions. Te aurere kura, the 25-year minimum strategy to eliminate family violence and sexual violence that I launched alongside Prime Minister Jacinda Ardern 15 months ago now, just over a year ago. It is a strategy grounded in delivering intergenerational change, and crucially, it sits alongside the first 2-year action plan. Jointly, they set out 6 shifts and 40 actions within those shifts that government and communities are working towards achieving over the first 2 years, all of which are absolutely underway. This is a 25-year strategy grounded in Te Tiriti o Waitangi, focused on the well-being of all people in Aotearoa. It recognises that a range of social conditions contribute to family violence and sexual violence. And I do want to highlight those 6 shifts. Shift 1 is towards strength-based well-being. Now this one, when we were travelling around the country and listening to communities, all sorts of communities, so many times that I heard myself, this isn't about violence, this is about us living good lives. It was bigger than the violence, and the communities identified that. It actually drove us to change our direction. It was about the communities demanding that we're focused on broader well-being, and that is what helps lead to living lives free of violence. It means that when people have affordable, warm, quality, safe homes and incomes and kai, and an education that affirms who you are, and access to health when you need it and how you need it, it means that Chaurere Kura automatically acknowledges that those basics are a key part of preventing violence, that well-being. It integrates all aspects of well-being by adopting the tokotoru model, is what we call the tokotoru model, which is it's a holistic approach, changing the social conditions, structures and norms that perpetuate harm. And just quickly on that, many of you know that through crisis, through weather events, through earthquakes and so on, unfortunately, the extra stresses can also lead to an increase in violence. Violence is never okay, but we have to understand and recognise that increased stresses is something that we all have to respond to and ensure that our services and support are always there, especially in these crisis times. Shift 2 is about mobilising communities. That is because what we are learning and getting better and better at understanding is that it is communities who will lead the most enduring work. It is communities who know themselves best, and they need to be resourced and authorised and affirmed to lead this work, to respond and prevent and heal. And so that came through our discussions across the country for Te Aorere Kura as well. Shift 3, well, we need a workforce. So shift 3 is about towards a skilled, culturally competent and sustainable workforces. And this shift involves ensuring the specialist, general and informal workforces are resourced and equipped to safely respond, heal and prevent and enable well-being. Shift 4. Well, forever, this country, countries around the world, have focused our energy focus and resources in response. Shift 4 demands investment in primary prevention. To achieve this shift, we must invest in a tiriti-based primary prevention model that strengthens the protective factors so that family violence and sexual violence do not even occur. And that will look different for every community, every group of people with different and diverse needs, and it must be led by those communities and by those people, but in partnership with government, with the sector, to be able to share and provide power and resource to do that work. Shift 5 is towards safe, accessible and integrated responses. This shift involves ensuring accessible, safe and integrated responses meet specific needs and do not perpetuate further trauma and harm on top of harm. And Elisabeth spoke about that. That they achieve safety and accountability. Shift 6 is towards increased capacity for healing. As I mentioned before, we've done terribly at that. To achieve this shift, we must increase capacity for healing and recovery and acknowledge and address trauma for people and whānau. I do want to pick up on some of the more specific sexual violence actions. A question that we often have is, what elements of the action plan specifically address sexual violence? So I'm going to just dive into those briefly. The actions that I mentioned, the 40 actions in the action plan, Action 10 is about developing and implementing trauma-informed sexual violence and family violence capability frameworks for workforces. One of the most common examples I hear and am met with in the community is where our schools, and many do the best job they can off their own backs, but as a system, we haven't provided the right responses for students and children who are displaying alarming and harmful, often harmful behaviour. A trauma-informed response is simply addressing what's under the hood and having the right responses then to allow students and whānau to receive the support they need. This is something that we're far too behind on, but this is something that the actions are beginning to address. We launched our family violence workforce tools last year with police, justice and corrections, the first agencies to adopt the tools, with more agencies to come. The sexual violence workforce capability tools are in development and evolving and will be informed and led by the experts and research like are here to acknowledge tonight. Action 14, and this is particularly relevant in the justice space, is building the specialist workforce for children. Dr. Kim McGregor has actually done some incredible work highlighting the very specific and specialist needs for children, but particularly in our court and justice processes. We've really got to get cracking on that work. Action 17 is developing tools to support healthy, consensual relationships for young people, but as Charlotte was whispering to me tonight, it's not consent on its own, it's understanding and identifying coercive control and power. Action 20, develop community mobilisation infrastructure to lead sexual violence. That's just empowering the communities, affirming the power of communities to lead. Action 22 is also developing and delivering sexual violence primary prevention campaign for Māori and Tauiwi. That's recognising the different needs, that's also recognising the violence and trauma of colonisation. Action 26, strengthen community-led solutions to prevent child sexual assault. Action 30, develop a plan to fill the service gaps for sexual violence, particularly. Action 35, design local Māori services for sexual violence healing and restoration. Te Aurere Kura launched an intergenerational plan and commitment, but it's also not in concrete. Every 2 years, we will have learnt and taken on board and developed the next lot of actions based on how much progress we have made over the past couple of years. It's a necessary and quite historic start, but it is just a start. Got a lot more to go. We have, though, worked really hard in our first year. We have cross-agency support and ministers taking collective action to identify opportunities for improving safety and support and minimising harm for victim survivors across our system and agencies. An example of this in action is working closely with Minister Kiritapu Allen, and I acknowledge her here tonight particularly, and very happy to step up into this place. Working with Kiri to look at opportunities for centring victim survivors in our justice system. That's this mahi. We are listening and working with communities, including those with direct experience of family violence and sexual violence, and supporting them to lead. We also have the support of Te Puna Aonui, some of the officials here tonight, the joint venture which brings together 10 government agencies to align policy investment and strategy, along with another 4 associate agencies. We are collectively focused on better outcomes for those impacted by family violence and sexual violence. And part of this is because the isolated way, the siloed way that our agencies and departments have been set up has not worked. We can only resolve this with authentic collaboration, not just across agencies, but that would be a good start, but also with community sector, with authentic partnerships of working together, bringing our best wisdoms to the table and recognising the value of each and every one of them. That has been hard enough as it is across government and Crown sector, but we're trying to stitch that up. This is our first action plan. We know we have so much more work to do. We are in the best position though, right now, than we've ever been in to lead this change. This is the biggest opportunity that we have seen to actually lead change. To conclude, tonight we compare notes, we share our resolve, we burnish our commitment. And we do all of that as we acknowledge and salute the contribution of this wonderful human, this committed academic, Professor Elisabeth McDonald. I just want to thank you all for this massive incitement and thought-provoking night and this contribution to our mahi. May it have the influence and the shaping of a better, safer future for everyone in Aotearoa that it absolutely deserves, that our people deserve. Thank you. Kia ora.
Ngā mihi nui. Tēnā koutou katoa. I'm Nicola Gavey from the Family Violence Clearinghouse, and I'd like to thank you very much, Minister, for your remarks tonight and for hosting us at Parliament, which is a real honour and, as you say, fitting for the status of this work. And I'd like to thank you very much, Elisabeth, for your presentation, which caps a remarkable body of research on rape trials, and as you put it, opens the door into the courtroom so that we can all see what's happening in such trials. And I think your sobering findings really confirm the observations of advocates, victims and survivors and others who have experienced and observed what's going on for many years. But the research provides a kind of compelling evidence of the systemic nature of these problems, and it also unpacks in fine grain exactly how and what is going wrong. So this research obviously is designed for a motivation for change. It's wonderful to see so many people here tonight who may be part of that change going forward. And so we're really pleased to be able to have time for some questions from everyone in the room. Joining Elisabeth for this Q&A are Paulette Benton-Gregg and Sandra Dixon, who are 2 of the researchers on the project. We're running a wee bit short from time, so I've just scribbled them a note saying I'm going to abbreviate their bios, right down to Paulette is from AUT Law, and Paulette works for Hoho Tuirongo Kahukura. Sandra, sorry, what did I say? Oh God. So thank you, yes, thank you. And just a reminder tonight that we are live streaming and recording this event. We're not filming the audience, but we are recording voices. So if you've got questions, we've got, thank you, roving microphones. And if you could speak into the microphone, that would be great so that the people who are listening at home can hear you. And it would be great also if you felt comfortable saying who you are, if you have got a question to ask.
We'll start on the questions, if that's all right.
Yes, thank you.
Because I have to go and make a speech. Kia ora, my name's Emily Henderson. Elisabeth, amazing work as ever. As someone who was involved in setting up the Sexual Violence Court and who actually wrote the original judicial training program for it, do I abandon all hope? Are we making progress in terms of, do you see progress in terms of how we're getting practitioners to act? And where to from here?
So just the little questions first. Thanks, Emily. Look, I have to acknowledge that the research like this takes time. So the most recent case in this research was 2 years ago and 3 years ago, and a number were earlier than that. So I think we can say over that time, there's work to be done. I do think myself, and I said this last week actually at a conference, the shifts that have been in my lifetime in relation to particularly rules of evidence have been applied. The leadership, I think, from the appellate courts has really shifted some of those decisions, and I think that the law reform is moving in the right direction. So I think that all judges, those sitting here of course included, would say that they will be working with those reforms and using them in the spirit with which they were enacted. So I think all of those things have to be positives, and don't give up yet.
Kia ora, Nikki Pender. I'm a barrister, and I do some victim advocacy and have a particular interest in witnesses and protecting witnesses and preparing them for court. Elisabeth, I just had my question was around your point around the lack of any evidence that communication assistants are being used, even when there seems to be a lot of cases where complainants are suffering from some sort of cognitive injury, often caused by the offending. And I'm just wondering, do you know, is that due to perhaps we aren't there yet in recognising perhaps adult complainants as vulnerable witnesses in, say, the same way as perhaps a child witness might be, or is it perhaps just simply a resourcing issue? I mean, can you see that changing anytime soon?
What's going on a bit, isn't it? Thank you, Nikki. So I think, again, I'd say this is slightly old research on that point. I think that most of us, those who are working in the courts, would see a much increased use of communication assistance. But my sense, and without having done the research on this, would be that it's still they're getting used more often in cases of children than in adults with cognitive impairment. And Fionnuala's nodding, so I'm taking that to be yes. So I think that there is some more need there, and I think that's obviously there were some women in the research that we did who were of high complex needs who could have really used that. But I think given that there's much more of a profile around communication assistance, there's more available. I think the Crown Solicitor's guidelines point in that direction, so I'm heartened that there will be a change there. I don't know if anyone else in the room would like to talk about that.
Kia ora, Jan Loki here. And this might be a little bit of a leading question, but Elisabeth, and thank you for the work. It's so valuable. But when you mentioned the government saying it needed more time and to investigate the money around the directions around family violence, do you have any update on that? Let us know when they said that and where we're at now.
I'm going to try and remember. So that was the government response to the Law Commission's report. So that was end of 2019. Is that ringing some bells? September maybe 2019. Yeah. So I cannot share any further insight into that except that that's what was said at the time.
Hi, I'm Christine French, Judge in the Court of Appeal. I would be interested to know what research has been done into the experience of rape complainants in other countries where inquisitorial systems are used, and how that compares with the bad experiences that we're hearing about in our current system.
Well, back in 2011, we published a book. So this was Jeremy Finn, Yvette Tinsley, and I, in league with Warren Young, who was at the Law Commission at that point. And the book is called From Real Rape to Real Justice. And that was part of that work. We actually went to a number of civil law jurisdictions and talked to them about how they approach. And I can just say that in brief, we have better practices in a lot of ways, but one of the things that came out of that was when Warren was at the Law Commission, he did put out an issues paper that was very well received, and one of the parts of that issue paper was moving the judicial role into much more of an inquisitorial model. Now, because that was a proposal that also suggested that there not be juries, the current Minister of Justice at the time did not want any work progressed on that, and it languished. So that work was done, it is out there. What I say at the end actually of in the absence of the jury book is time to go back to that, because there was never actually firm engagement with those possibilities. Yeah.
Kia ora, ko Suzanne Kent tōku ingoa. Kia ora, Elisabeth, thank you for your work. Excuse my voice. I am a doctor who's been working in the area of sexual assault for 25 years, and currently working in Wellington, part of MedSAC, which is Medical Sexual Assault Clinicians. I was interested in your research, particularly around expert witnesses and the lack of expert witnesses that have been called. We've also noticed a real drop-off, actually, in the time that we get called to court as expert witnesses, and I'm just wondering if you've got any comment on that.
No, I've got a nudge for Nola on that one as well. I was focusing, I guess, specifically on that issue about expert evidence around the counter-narrative, but also not much going on in any other space either there in terms of memory or in terms of intoxication or injuries, just very low numbers generally in the sample that we were looking at. So
Okay, we might.
Nice.
Thanks for all those really great questions, and I think it's starting to really open up some really important discussion, which there'll be time to continue over a glass of wine, perhaps, or something. But just before we do that, I just want to ask Sandra Dixon, Paulette Benton-Grieg, who were involved in the research, whether you had any comments that you wanted to add?
Hugely important project, and your tenacity in getting it done has been amazing. Congratulations.
Hang around. I want a hug too. I guess it has been a long piece of work, this one, eh? We've been working on it together for a long time, and I think that for all of us that have been involved in this is not new work for us, but it was really gruelling. It was really gruelling for even very experienced people in this area to listen to what is happening for women in court when they try and talk about experiences of rape. So that's my first kind of reflection. I'm also grateful for your tenacity, I have to say, Elisabeth, in a whole bunch of ways, from the reality of research where, gosh, we thought that was going to be enough hours and actually it isn't. Let's rejig that, which happened a lot. But also just to the kind of reflective care we took with one another as we worked through the material, because it was hard. I have one reflection on this last book and this last piece of work, which is that one of the things that was happening in these cases that was different was that women were talking about experiences where partner violence had also happened. So that meant often that women had sought legal protection around partner violence experiences, protection orders, reporting physical assaults and so on. One of the things that was interesting in these cases was that where protection orders had been sought before women had disclosed rape, if they hadn't talked about sexual violence in those protection orders, that was seen as problematic for their credibility. Now, anyone who's worked in these fields knows that sexual violence is the last thing that people talk about, and that often in protection orders and so on, they're not even being asked about that arena of their lives. So that separation of family violence and sexual violence is really harming us in all kinds of ways, and it was quite obvious, I think, in these cases, one of the ways that that's happening. Yeah, that's all I have to say, and now I want my hug.
So thank you, everyone. I also just wanted to acknowledge and thank you, Marama, for your sharing your story as well, and uplifting the voices of survivors. And just, to reiterate what everyone's saying, thank you, Elisabeth, for this research and the broader team. This is intense, expensive research that requires kind of expertise spanning understanding of the dynamics of sexual and family violence, as well as the kind of intricate understandings of legal complexities and laws of evidence and things that completely go over my head. And it's just such a unique opportunity that we have this, and I really hope that it does inform substantive change and bring Warren Young's words to life. Before we go to drinks, we have the very important next step of actually officially live launching this book. So we're going to hand over to Catherine Montgomery from Canterbury University Press, which, as we've already been told tonight, published all three of Elisabeth's books. Thank you, Catherine.
Looking at my watch. Tēnā koutou katoa. Ka tuku aku mihi ki te mana whenua o tēnei rohe, arā ko te Aotearoa taranaki whānui. Tēnā koutou. Rōranga mā, ka nui te mihi ki a koutou katoa. Ko Catherine Montgomery tōku ingoa. Nō reira, tēnā koutou, tēnā tātou katoa. And the champagne's popping already, so I really must move on. Thank you, Nicola, where have you gone? For that introduction, and greetings to everyone this evening. I'd like to acknowledge the mana whenua, Minister Davidson, Tupe Solomon Tanoai, and all at the Borrin Foundation and the New Zealand Family Violence Clearinghouse. As I've said, I'm Catherine Montgomery, publisher at Canterbury University Press, and it will be my pleasure very soon to launch Elisabeth McDonald's new publication, Prosecuting Intimate Partner Rape. By now you've got a good understanding of the research on which it's based, so I won't talk about it really. But I did want, and I'd be grateful to have a few minutes to look back at some of the milestones of the publishing journey with Elisabeth. And I've crossed out lots of bits as I've gone along. But when I first met Elisabeth in 2019, she was lecturing at the University of Canterbury, which is how we got to hear about her research. And we immediately wanted to come on board as publisher, or I was going to say midwife, but at the time we thought it would be, one, not triplets over 5 years, but we were delighted to be midwifing throughout that time. As you've just heard, Elisabeth is preeminent in her field. In fact, you haven't just heard, because I had a quote there from Scott Opticon about her being New Zealand's premier researcher in and advocate for the reform of criminal trial processes involving adult victims of sexual violence. But there was clear potential for the publication to have a positive social impact via its intended audience, including obviously the judiciary, but also health workers, policymakers, and students of law, criminology, criminal justice, and sociology. And that first book, Rape Myths as Barriers to Fair Trial Process, published in 2020, was our first open access publication. We were putting our toe in the water, As a university press, we seek to contribute to scholarship in Aotearoa and internationally, and to publish work that benefits the wider community. But of course, the open access pathway makes publications not only widely but freely available, and we've been very grateful for sponsorship towards production costs for all 3 titles. I think, as Elisabeth has acknowledged, from the Law Foundation, UC School of Law, and the Michael and Suzanne Borrin Foundation. With that first book, we were off to a great start. There was immediate and widespread interest following the release of Rape Myths, and this was an excellent opportunity to raise awareness of the issues even more widely in society. And for that book, Elisabeth was joint winner of the J.F. Northey Memorial Book Award in the Legal Research Foundation Writing Awards. They said, "The competition in this category was stiff and fierce. Your book will make a significant contribution to this difficult and evolving area of criminal practice and procedure." There was praise too in the Canterbury Law Review of the book's depth of scholarship, matched only by the moral clarity of her vision for reform. And interestingly, ESR, Institute of Environmental Science and Research, used information from her excellent work on rape myths for a report on experiences of the forensic medical exam after sexual assault. So it was really gratifying to us to see how useful the book was being already. That book was followed in 2022 by In the Absence of a Jury, the research being the first in the world to specifically compare jury trials involving adult rape allegations with trials heard by a judge only, with some surprising and disappointing results, and provided further support for the argument for change. Criminal lawyer Andrea Ewing said that every book Elisabeth wrote in that area became required reading for those working in the system, and the latest was no exception. Just a few statistics. I won't overload you with numbers, but because it's open access, we can look at usage statistics. And I remember when Rape Myths came out, we were just looking at the research repository figures, which aren't totally reliable because every time we clicked on it, the numbers went up. But, you know, there were thousands straight away. But we have some more stringent sort of perhaps stats from Google Analytics. So, you know, more than 4,000 sessions for Rape Myths since publication, slightly fewer, you know, nearly 1,000 for the jury judge alone trial book, and the majority of users being in Oceania, particularly New Zealand, obviously, but followed by those in Europe, the Americas, and Asia. So, good old Scott Optican, in his review of the second volume, he anticipated the book we're launching today, predicting, if her past work is any guide, this final volume will ensure that McDonald's 3-book series will take its rightful place as one of the most significant pieces of New Zealand's legal scholarship ever penned. No pressure then, Elisabeth. So following the approach of the 2 previous volumes, the new book, as you know, focuses on intimate partner rape trials. And it had been something that had been under-researched, partly because rape in marriage wasn't recognised as a crime in Aotearoa until the 1980s, which, you know, for young people today, but also because of the research silos, the fact that there's a lack of intersection with research into domestic violence. And this new book, again, harnesses Elisabeth's meticulous approach. I think it's been called granular, you know, this fine-grained research, and her sensitivity, which, you know, remarkably has been honed rather than blunted after so many years working with this really challenging material. And again, in this book, analyses of transcripts and audio recordings allowed a more nuanced understanding of the experience of the complainants. So the author-publisher relationship is a hugely collaborative one, especially we found with this sort of interactive online material. So it's a big bonus for us when an author is such a pleasure to deal with. You'd all know that, I know, but Elisabeth's been a responsive and refreshingly organised author, which really is makes it a lot easier. And she brought the energy and dedication that a publication of this form and scale demands, but also her personal qualities of kindness and generosity and good humour, which were all much appreciated by the team who were charged with helping her complete the project within an ambitious time frame. She'd come to us and say, "What do you think we could do it by then?" And we go, "Oh, okay," and we have. So And I'd like to acknowledge that team. Obviously, Elisabeth's contributors, Paulette, Sandra and Rachel, and the editorial and design team, but especially the project editor, Katrina McCallum, who can't be here tonight, and designer Robin Greathead, who've worked on all 3 titles. They've again put a huge amount of care into this free digital publication, just as they would into any print book. And I think that's really important to remember, because people think, oh, you know, it's online, doesn't matter, but actually so much care has gone into it. And Robin's thoughtful approach has again made this interactive online edition both good-looking and user-friendly. And I'd like to thank the University Library staff for making a home for it in the research repository. And we are very grateful to the Michael and Suzanne Borrin Foundation for generous funding of the publication of the open access edition. So I'd like to thank you all for your kind attention at the end of a demanding program. I did just want to say, following what Minister Davidson said, it makes you think about things in a generational way. My first child was born in 1996 when Warren Young said that he hoped that in 10 years things would have changed. And his daughter was born this year, my first grandchild. So, you know, when she's in her early 20s, you know, one hopes that the Te Aotearoa, the outcomes will be bearing fruit for women of her generation. I'll finish, or nearly finish, with a Boris Pasternak quote. I was reminded of it at a publishers' conference last year, which, because of, as you'll understand, various things I find myself returning to increasingly often in the world we live in. And it is, remember, you must never, under any circumstances, despair. To hope and to act, these are our duties in misfortune. But these volumes Elisabeth has published help us to understand, however, why complainants in sexual violence trials would despair of the trial process, and why there are extraordinarily high attrition rates in this area of law. So we're very lucky that despite the fact that the adversarial aspects of trial process have proved to be very resistant to change, Elisabeth McDonald has not given up hope of reform and has dedicated herself to this study for so many years. Sorry. So Elisabeth, you've been on this journey a lot longer than we've known you, but Katrina and I feel privileged to have joined you for part of it, taking this challenging and important work from manuscript to publication. Congratulations on this book and on the completion of the trilogy. This is the latest triplet here. This is the print. I'll give that to you now. It's a bound proof. Congratulations on this book and on the completion of the trilogy. And without further ado, you'll all be sighing with relief. I hope to be able to press a button or two and declare this book formally launched. Now, you didn't tell me which button it is. So that one. There. There, here we are. Namihi.
Kia ora koutou. So that closes the formal part of our evening, and before we move into having a drink and reflecting, I'll close us with a karakia. I'm going to invite Tupe to close us today. Kia ora, Tupe.
So this is a karakia mō te kai. Nau mai ngā hua o te wao, o te ngākina, o te waitai, o te wai Māori, nā tāne, nā rongo, nā tangaroa, nā maru. Ko ranganui e tū e hōnei, ko papatu anu ku e tā koto nei. Tūturu o whitika whakamaua ki a tīna. Haumie, hui e, tai ki e.